Chap. 14. Criminal Acts. Section 1. In general, the disabilities which we have seen to arise out of the incapacity of the unfortunate objects of this work, proceed from the principle of protection which the law affords them, and this protection is farther extended even where their wild indiscretion has led them to violate the laws themselves. They are forgiven for they know not what they do. They ought not to be prosecuted for any crime because they want knowledge to distinguish between good and evil. Idocy being a defect from birth is generally to be protected from punishment, but lunacy, which is a partial derangement, the senses returning at uncertain intervals, the offender is only protected from punishment for acts done during the prevalence of the disorder, for he is then sufficiently punished by his madness, which prevents him from affording by punishment any example to others. No guilt, which is the gist of criminal process, can attach to any person while he is incapable of reason or design, and as the evil intention is the implication of every offense, and therefore the charge of every indictment, a deficiency of will is held to excuse the overt act, for there is no human mode of trying the secret motive but by the overt act. If therefore the overt act is proved, it is perfect justice to imply the motive which cannot be proved, for confession is not to be the means of conviction. It is the extreme of the doctrine that a man cannot stultify himself. Any crime committed by an idiot or lunatic can arise only from defective or vitiated understanding. It would be unjust therefore to render him chargeable with his own acts. Furious furore solum punitia. If a man in his sound memory commits a capital offense, and before his arraignment becomes insane, this will stay the arraignment, because he is unable to plead under proper caution and advice. If after the arraignment and plea he becomes insane, his trial will be stayed, for he is then incapable of making his defense. If by some oversight, or by means of his jailer, he plead to the indictment and is put upon his trial, and it then appear to the court that he is insane, the judge in his discretion may discharge the jury of him, and remit him to prison to be tried after his recovery, and this caution is more essentially necessary in favorem vitae where any doubt appears upon the evidence touching the guilt of the fact committed, and if there be no colour of evidence to prove him guilty, or if there be a pregnant evidence to prove his insanity at the time of the fact, then upon the same favour of life and liberty, it is fit it should be proceeded in at the trial in order to his acquittal and enlargement from justice, for by reason of his incapacity, he cannot act felio animo. If it were doubtful, at his trial, whether he were lunatic or not, that question was first tried by an inquest of office to be returned by the sheriff of the county wherein the court sat, and if they found that the party only feigned and still refused to answer, he was dealt with as one who stood mute. Every person of the age of discretion is presumed to be of sane memory until the contrary appear, which may be either by the inspection of the court, and by evidence given to the jury who are charged to try the indictment, or it being a collateral issue, the fact may be pleaded and replied to or tenues, and a venire awarded returnable instanta in the nature of an inquest of office, and this method in cases of importance, doubt, and difficulty, the court will in prudence and discretion adopt. If, after a man be tried and found guilty, he lose his senses before judgment, that shall not be pronounced. If after judgment he becomes insane he shall not be ordered for execution, for had he been of sound mind he might then have offered something in stay of execution, an argument which also applies to all the former proceedings. It is therefore an invariable rule when any time intervenes between the attainder and award of execution, to demand of the prisoner what he hath to allege, why execution should not be awarded against him, and if he appears to be insane, the judge in his discretion may and ought to reprieve him. If the punishment were less than death and were inflicted upon a prisoner deprived of reason, it would be unproductive of one of the great ends of punishment, the correction of the criminal, and to prevent his doing further mischief to society. Human tribunals are only justified in introducing the pain and evil of punishment when it is likely to prevent that greater degree of evil which would result from the unrestrained commission of crimes. Indeed, in the bloody reign of Henry VIII, a statute was made to authorize the trial of a lunatic in his absence, charged with high treason, and to sanction his execution, if convicted, as though he had his perfect mind. But this act was wisely repealed by 1 and 2 P. and M. c. 10. But if a lunatic hath lucid intervals he shall answer for what he does in those intervals, as if he had no deficiency, yet this may be avoided by his not being suffered to go at large. It was the doctrine of the ancient law that lunatics might be confined till their recovery, without waiting the forms of a commission or other special authority from the Crown, and now by the Act for Confining Vagrants, 17 Geo. 2. c. 5, already mentioned, this is provided for. If one who wants discretion commit a trespass against the person or possession of another, he shall be compelled in a civil action to give satisfaction for the damage. The great difficulty in all these cases, is to determine where a person shall be said to be so far deprived of his sense and memory as not to have any of his actions imputed to him, or where notwithstanding some defects of this kind he still appears to have so much reason and understanding as will make him accountable for his actions, which Lord Hale distinguishes between and calls, by the names of total and partial insanity. And though it be difficult to define the indivisible line that divides perfect and partial insanity, yet, he says, it must rest upon circumstances duly to be weighed and considered both by the judge and the jury, lest on the one side there be a kind of inhumanity towards the defect of human nature, or on the other side too great an indulgence given to great crimes. And the best measure he can think of is this: such a person, as labouring under melancholy distempers, hath yet ordinarily as great understanding as a child of 14 years hath, is such a person as may be guilty of felony or treason. Imbecility of the plaintiff is generally no good objection against his bringing an appeal of felony, and c. For as the defendant has the proper means for his acquittal, by putting himself upon a trial by his country, and the imbecility of the plaintiff is wholly owing to the act of God, and no way lessens the injury complained of by him, it is not reasonable that he should suffer any disadvantage from it. But the total incapacity which attends upon an idiot, or one born deaf and dumb, prevents him from bringing any appeal whatsoever. So likewise an idiot or person deaf and dumb, or any one that is non-compass at the time, cannot be an approver, to prove his appeal, because no such person ought to be admitted to take the oath before the coroner, without which there can be no approvement, nor can he wage battle. Although the old doctrine seems to have allowed of punishment for inferior crimes, and of damages for civil injuries, committed by lunatics, yet the liberality of modern times would rather waive any such right and relax the pursuit of punishment, or remedy, against an offender who could not have that design which constitutes the criminality. It is to be assumed that all men are born in a state of sanity. This is the common disposition of nature. Reason is the lot of man, it is that which distinguishes him from other animals. A man without reason is little more than an organized body, which only retains the shade and figure of a man. His state is a kind of prodigy and monster in nature. Hence arises that common presumption that every man is in a state of sanity, that insanity ought to be proved, but that a proof of sanity is not necessary. Nothing is more difficult than to prove the fact of insanity. It is not only to combat natural presumption, it is also to render an invisible and interior quality sensible and visible. It is with this precaution that the plea of insanity can only be set up in excuse for substantiated crime. Section 2. Suicide. Upon the principles already laid down, a person who loses his memory by sickness, infirmity, or accident, and kills himself, is not fellow de se, otherwise if he kills himself in a lucid interval. So if he give himself a mortal stroke while he is non-compass, and recover his understanding and then die, he is not fellow de se, for though the death complete the homicide, the act must be that which makes the offence. But it is a vulgar error that none of sane mind can be fellow de se, and that whosoever kills himself must be non-compass, for if he be non-compass as to other acts, that sole act shall not denominate him non-compass. And here I cannot but take notice of a strange notion which has unaccountably prevailed of late, that everyone who kills himself must be non-compass. Of course, for it is said to be impossible, that a man in his senses should do a thing so contrary to nature and all sense and reason. If this argument be good, self-murder can be no crime, for a madman can be guilty of none, but it is wonderful that the repugnancy to nature and reason, which is the highest aggravation of this offence, should be thought to make it impossible to be any crime at all, which cannot but be the necessary consequence of this position, that none but a madman can be guilty of it. May it not with as much reason be argued that the murder of a child, or of a parent, is against nature and reason, and consequently that no man in his senses can commit it. But has a man no use of his reason because he acts against right reason? Why may not the passions of grief and discontent tempt a man knowingly to act against the principles of nature and reason in this case, as those of love, hatred, and revenge, and such like, are too well known to do in others? The same mode of reasoning may very easily be extended to excuse the blackest crimes, for nothing can be so contrary to reason and nature, and to all the best interests of life and immortality, as the commission of them. The Decalogue forbids man to commit murder, in which precept self-murder seems no less to be understood, than the murder of another, though the individual has eluded the vengeance of offended justice, yet with a view to discourage the crime, our laws punish a son for having thus lost a father, and a widow because she is thus unhappily deprived of her husband. Confiscation of the goods of the deceased, is depriving the survivors of their due. By adopting this remark I cannot be charged with defending suicide. Montesquieu asserts the English destroy themselves of 10 in the very bosom of happiness, that it is the effect of a distemper, connected with the physical state of the machine, and independent of every other cause. The civil laws of some countries may have some reasons for branding suicide with infamy, but in England, upon the principles generally adopted, it cannot be punished without punishing the effects of madness. Section 3. Murder. Lunacy is an excuse for murder, for which a madman shall not lose his life, for no punishment of him can be any example. So an insane woman by killing her husband cannot commit petty treason, though the same act against the person of the crown was held to be high treason, for the king is caput et salus rubs. A to capite bona valicido transit in omnes. 5. Besides, if a madman kill another he hath not broken the law, although he hath broken the words of the law, for he had not any understanding, but mere ignorance, which is the visitation of God. A feme covers notwithstanding killing either her husband or another, is nevertheless entitled to dower, the crime not being imputable to her. In the state trials 2 cases are reported material to this subject. Edward Arnold was indicted at Kingston, before Mr. Justice Tracy, for maliciously shooting at Lord Onslow. There was not a doubt that he was deranged, and particularly in relation to Lord Onslow himself, whose conduct he had very much misconceived. It appeared in evidence, that he had conceived a regular steady design, and had prepared the proper means for carrying it into effect. The court admitted the proofs, but whether the act was done maliciously, and c. was to be deduced from the nature of the insanity on which the jury were to decide. It was laid down that if he knew not what he did then he could not be guilty, but it was not every kind of partial insanity that would excuse him, but such a deprivation of reason as made a man know no more than a brute, or an infant. This exposition of the law has never since been controverted, but has been adopted in subsequent decisions. The jury found him guilty, but he was not executed. He was reprieved at Lord Onslow's request, and remained in prison 30 years. The case of Lord Ferrers, before the House of Lords, who had killed Mr. Johnson, was, that he was occasionally insane. The murder was deliberate, but he was not punished, for it was proved that he did not know what he did and was incapable, from fits of insanity, of judging of the consequences of his actions. It was urged upon the authorities of Coke and Hale, that it was not necessary to have a complete possession of reason, but a sufficient degree of it to comprehend the nature of the action and to discriminate between moral good and evil, to warrant the judgment of the law taking place. He was found guilty, it appearing that at the time he committed the fact he had capacity of mind sufficient to form a design and to know its consequences. Section 4. Treason. The protection of the person of the monarch has ever been dear to the people of England. It has, from the earliest times, and never was more sincerely than at the present day, been surrounded with laws which have been established by universal consent, and with affections accompanying the graver obligations of allegiance and fidelity. The elevated station of the crown as the first estate of the realm, the caput et salus republis, has been guarded by such a rampart as must prove impregnable while the sanity of the people remains unimpaired, and the final visitation of heaven is suspended. The bona valicido qna transit in omnes must be lost at its source, and its channels become dry, before its banks can fall in and its barriers be rooted up. But the charge of the worst of crimes, the murder of the king, must yet be tempered with discretion. The law, though jealous of the least approach to this offence, will spare in its deliberation the condign punishment it deserves, when insanity accompanies the crime, for in our ideas of great crimes there should be nothing arbitrary in the jealous and violent reign of Hen. 8. Even this mild humanity of the English law was forgotten. He was resolved to establish himself in absolute power, and to compel his council to aid his designs, in which the Parliament were in some acts not inclined to oppose his wish. In one of these we find them yielding to criminal vengeance in the punishment of lunatics for high treason. 1541. It was suggested in the preamble to the statute that lunacy was falsely contrived to delay the punishment, and therefore directed that a special commission should be sued from the Chancery upon the certificate of forecounsel to inquire of the treason, upon which a jury should be empanelled to try the offence in the lunatic's absence, and if found guilty he was to be punished as if of sane memory. If the lunacy followed the attainder or conviction, punishment was alike to ensue. Attainders by common law were declared as effectual as those by Parliament, and the king's benefit of uses was saved, saving also the rights of all persons, except those attainted. But the sounder understanding of the law gave a better protection to the prerogative and person of the crown. In the subsequent reign the principle of natural justice was declared to be the law of England, namely, that a lunatic cannot be punished as an example to others. The ancient law was, that if a madman had killed, or offered to kill the king, it was held for treason, and so it appeared by Alfred's law before the Conquest, and is recognized in Beverley's case, but by Stat. 25. Edward. 3. Stat. 5. c. 2. And by force of the words compassing and imagining the death, he that is non-compass and totally deprived of all compassings and imaginations cannot commit high treason by compassing or imagining the death of the king, but it must be absolute madness and a total deprivation of memory, without which he could not be found guilty by this statute. And the ground on which the act of Hen. 8. was justified was to guard against its being made a pretence and excuse, but it was seen by the more humane disposition of after times that the exhibition of so miserable an object as insanity, in the act of receiving the vengeance of offended justice, was more likely to produce very serious effects than to excite example, the express purpose of which sprung from a nobler cause. At pena metis ad omnes perdoniat. This matter was therefore cleared by the statute of 1 and 2 Ph. and Mary, c. 10, which directed that all trials for any treason shall be had according to the due order and course of the common law, and not otherwise, saving to all persons other than offenders, and such persons as claim under them, all such rights as they had at the time of committing such treasons or at any time before. The most recent case in which lunacy was effectual to excuse a man guilty of treason was that of James Hadfield in 1800, who was indicted and tried at Westminster Hall before a special commission, for having on the 15th of May, maliciously and traitorously encompassed, imagined, and intended to put the king to death, by buying and procuring a certain quantity of gunpowder and leaden bullets with which he loaded a pistol, and having so armed himself repaired to Drury Lane Theatre, and there discharged the same at the person of the king. He had formerly been deranged, and for that cause had been discharged from the army, but it was urged, that on the day of this fact he was sufficiently sane as to warrant the credit of guilt as stated by Lord Hale, that the degree of sound mind necessary for the discharge of a continued duty is very different from the state of mind necessary to combine guilt as to one deliberate act, and the principles already laid down of lucid intervals giving validity to contracts were likewise urged, but that the degree of sanity necessary to give validity to a contract was not necessary to enable a jury to pronounce guilt, for the distinctions between right and wrong are deeply engraved in the mind, and the traces of that distinction are never totally erased while the mind has the capacity of retaining anything. It was proved that the prisoner, at the moment of the audience rising on His Majesty's entering his box, got up above the rest, and presenting the pistol loaded with slugs, fired it at the king's person, and then let it drop. He had sat in his place 3/4 of an hour before the king entered, and he appeared to be in a situation where a good aim might be taken. Standing upon the second seat from the orchestra in the pit, he took sufficient time to take a deliberate aim by looking along the barrel as a man does who takes his aim. When he was apprehended, he said, This is not all, this is not the worst that is going forward, and said to the Duke of York, God bless you, you are a good fellow, you are His Royal Highness the Duke of York, who afterwards recognized him to have been one of the orderly men of dragoons attendant upon His Highness at the Battle of Famars, said he knew perfectly well his life was forfeited, that he was tired of life, and regretted nothing but the fate of a woman who was his wife, and who would be his wife a few days longer as he supposed. These words he spoke calmly, without any apparent derangement, and so continued. He repeated that he was tired of life, that his plan was to get rid of it by other means. He did not mean anything against the life of the king, he knew the attempt alone would answer his purpose. It also appeared in evidence that he had in the morning showed a pair of pistols to a friend, alleging that he had bought them for his young master, and that after cleaning them he should make a profit of 4 shillings, and left one of them with him, lest both should frighten his wife, and appear then to be perfectly cool and collected, though in lower spirits than usual. In the defense, by Mr. Erskine, those cases were relied on where insanity has been held to invalidate contracts, wills, and c. That Lord Hale calls insanity, a total deprivation of memory, but this could not mean merely recollection, for a man may forget, whether he be a subject and bear an allegiance to his king, and yet not be a lunatic. On many occasions he is possessed of a subtle memory, strong passions, violent emotions, gusts of fury, are not insanity. That is, when the mind is under the influence of delusions operating upon them, whose reasoning proceeds upon something which has no truth, no substance nor foundation, but is vainly built upon some morbid image formed in a distempered imagination. Confirmed maniacs have been found to reason consistently on various topics, and will frequently baffle the least suspicion of their insanity until some unexpected point discover the vulnerable state of their mind. 2 cases were stated of this nature. In one upon a prosecution against the keeper of madhouse for illegal and malicious detention, when after a long examination, in which the case was almost confirmed, at the sudden appearance of Dr. Simmons upon the bench, the witness proclaimed him to be God and the Saviour of the world. The other case was similar against Dr. Monroe. The indictment was laid by a Mr. Wood, who gave his evidence very consistently till the sudden appearance of Dr. Beatty struck upon the chord of his insanity. He was permitted to ask the witness what became of his amour with the princess. He replied, that she was imprisoned in a lofty tower, and their correspondence was interrupted, as all her letters fell into the water which enclosed the place of her confinement. Wood preferred a second indictment, and all the most ingenious cross-examination could not extort from him a single acknowledgment that he recollected anything of this imaginary correspondence, not that his fancied love was extinguished, but that he was determined against a second defeat upon the same grounds. On these cases it was contended that insanity is capable of assuming, and exhibiting the appearance of sanity, except when it amounts to a degree of absolute frenzy, and it was allowed that if a man commits with premeditation, for that must always be included, a criminal act under the dominion of mischief and malice, he would in law be responsible, although as to other things he might be actually insane, because in what he does then he is not under the dominion of his malady. Where the party is under that dominion, the case is exactly the reverse. During the time that Hadfield was acting under the impressions adduced in evidence, he discoursed very reasonably, and had his perfect recollection while he imagined he was acting under the command of heaven, and there was no evidence of his having associated with seditious persons who might have inflamed his mind. The almost deadly wounds which had disordered his brain, his frequent confinement in fits of insanity, his general character, boiling with loyalty and attachment to the royal family, his mixing his own madness with that of Truelurk, a cobbler, whose committal for insanity was produced, all, and many other particulars, showed him to be non compos mentis. This defence was supported by evidence that proved the prisoner to have been a private dragoon of the 15 Regged. In 1793 and wounded in the action on the 18th of May, near Lisle, left for dead on the field, carried to the hospital in a state of insensibility, afterwards called himself King George, and when he saw himself in a glass felt his head for his crown. When he was recovered sufficiently to be in the garden, his comrades called him King George. He replied, that was all over now and done away with, and appeared quite sensible that 3 of his wounds had probably penetrated his skull and injured his brain, and after injuries of the brain from wounds there frequently follows the loss of some particular sense, sometimes the loss of sight or of hearing, sometimes a loss of memory followed by insanity, and if that immediately follows and continues for 2 or 3 years it becomes permanent. It may not be constant, but will be excited by particular causes and circumstances. It often happens that a person thus affected is at one moment perfectly rational and seemingly in the full exercise of reason and all the powers of the mind, and at the next moment the paroxysm follows. That when common questions were put to him he answered correctly, but when any were put which related to the subject of his lunacy, on religion, and on his crime, he answered irrationally. That paroxysms come on periodically. The approach of hot weather has often this effect, but are more frequently produced by something in the state of health, or by some external circumstance oppressing or leaving violent or sudden influence on the mind, or by the food or manner of life. That on account of his insanity he had been discharged from the army, had since been necessarily confined to his room for 10 days, and had been in various fits of bawling and hallooing out. They came on with the hot season, and at the changes and full of the moon. He then called himself a prince, Jesus Christ, and sometimes God. His dejection gave signs of the fit's approach, that then his eyes stared, he was very surly. That on the 11th of May he was growing worse, said Jesus Christ was a damnation blackguard, and often repeated that he was going a long way and had a great deal to do. On the 13th said on his return home that he had been to see God, that the Virgin Mary was a bloody whore, that Jesus Christ was a damned bastard, and God was a thief, that he went out again, drank a part of a pot of beer, and returned home in the evening using similar indecent expressions. After supper said he was ordered to go into the garden to pray for 3 hours between 9 and 12 o'clock, and that he was to see God, called himself God Almighty's servant, and was going to build a house in White Conduit Fields where he was to live with the cobble at Rulock, that he was to be God and Treatise Lock to be Satan. That about 1 or 2 in the morning he suddenly jumped out of bed, and referring to his child, a boy of about 8 months old, of whom he was usually remarkably fond, said he was going to dash his child's brains out against the bedpost, said, "God damn his little eyes, I will kill him," that God had ordered him to do it. On his wife screaming and his friends coming in, he ran into a cupboard and said he would lie there, it should be his bed, and God had said so. In doing this he had overset a kettle of water, and said he had lost a great deal of blood. In the morning he denied that he had got up or awake during the whole night, shook his fist at his wife and said he would murder her. In the following day he repeated his former expressions about God, and the Virgin Mary, and Jesus Christ, and during the very next night had frequent startings in his sleep, and appeared much worse in the morning, said he had seen God in the night, that the coach was waiting, and that he had been to dine with the king. Spoke very highly of the king, the royal family, and particularly of the Duke of York, went out to his master's workshop, and returned to dinner at 2, but would not eat any, said he did not need meat, and could live without it, asked for tea between 3 and 4 o'clock, talked of going to be a member of the Society of Odd Fellows, repeated his irreligious expressions and then went out. This was the afternoon on which he went to the theatre. That when in his right mind he was a very tender and attentive husband, and even when he was deranged his wife could manage him, that ever since his return from France he had been annually deranged from the beginning of spring to the end of the dog days. On the 13th of May he said he was a prophet, and that he must eat no more as the Lord Jesus Christ had forbidden him. From this evidence the Lord Chief Justice Kenyon held that being deranged immediately before, it was not very likely that in the interval he had recovered his senses. If they were to run into nicety, proof might be demanded of his being insane at the very moment when he committed the act, that there was no reason to believe that he was a rational and accountable being when perpetrating the deed. The jury concurred with the court in this opinion and gave their verdict to be recorded thus: not guilty, it appearing to us that he was under the influence of insanity when the act was committed. It was agreed that he should not be discharged. He was therefore reconducted to Newgate until he could be otherwise disposed of. Consequent to this trial, the legislature passed an act in the July following, declaring that in all cases where it shall be given in evidence upon the trial of any person charged with treason, murder, or felony, that he was insane at the time of committing the offence, and shall be acquitted, the jury shall find specially whether he was insane at that time, and declare whether he was acquitted by them on account of such insanity, and the court shall then order him to be kept in strict custody, as they shall think fit, and so in all like cases before the passing that act, which warranted the detaining of James Hadfield sect. 2. And if any person indicted shall be insane, and be so found by the jury upon arraignment, or appear so to them upon the trial, the court shall direct such finding to be recorded, and order him into strict custody until the king's pleasure be known. If any such person be brought up to be discharged for want of prosecution, the court may order a jury to be impaneled to try his insanity, and on their so finding, the court may order his confinement in like manner, and the king may give such order as he shall think fit. Sect. 3. And in order to prevent crimes by lunatics, if any person shall be discovered and apprehended under circumstances that denote a derangement of mind and a purpose of committing some crime, for which, if committed, he would be liable to be indicted, and if any justice of peace shall commit him as a dangerous person suspected to be insane, such cause being expressed in the warrant, he shall not be bailed, except by 2 justices, one of whom shall be the first mentioned, or by the quarter sessions, or great seal. Sect. 4. Insane persons having at different times endeavored to gain admittance to the king by intrusion in his usual places of residence, it was therefore provided, that if any person who shall appear to be insane shall endeavor to gain such admittance, and there may be reason to apprehend that the king's person may be so endangered, the Privy Council, or one of the principal secretaries of state, may order his confinement, and the Great Seal may issue a commission to inquire into his sanity, and whether the king's person may be so endangered, and direct the sheriff to summon a jury accordingly, and if they shall find him so insane, the Great Seal may order his confinement so long as there shall be reason to apprehend danger to the king's person, and afterwards inquire into his recovery and direct him to be discharged absolutely or conditionally, or under restrictions as shall seem meet. In consequence of this act, the judges have remanded prisoners, who have been found to be lunatics, to their prisons, until His Majesty's pleasure be known, where they have remained under the care of the keepers, and have been attended by such medical skill as the county has afforded, but their number is now greatly increased, which has justly excited the farther attention of the legislature.